My name is Karen Harding and I am a criminal defence lawyer in New Zealand. I would like to take this opportunity to present draft 4 of a chapter of a research paper I have prepared. The research paper is titled Re-engineering Rural Justice in New Zealand, Problem-Solving Justice in Action, a Charter Court Solution for Apoteiki in Tuhoe. Draft Chapter 4, my draft number 45. Chapter 4. Governance issues in remote communities with disadvantaged populations. Subsection A. Absence of basic justice and governance and its effect on rural communities. Areas with compromised justice and governance are linked to high rates of violence and mortality. An absence of governance and justice in remote communities can serve as a spur to lawlessness, impinging on the welfare and security of residents. Social disorganisation theory assumes strong networks of social relationships prevent crime. Social disorganisation arises when community members are unable to achieve shared values and to jointly solve experienced problems. Patterns of abuse, bullying, victimisation and control, much of it fueled by alcohol and substance abuse, can become normalised in communities cut off from economic opportunities, public services and with deficient social institutions. Marcia Langdon describes this as lateral violence. Communities can turn in on themselves with damaging consequences on women and children. Cultural and society norms can become distorted. There is an absence of traditional authority figures and structures. These issues are considered in relation to the Bay of Plenty and Apoteiki and the Uawaras. The Apoteiki District Court cannot afford to fund social development through rates, as 70% of the land is non-rateable, being either conservation or Maori land. The Apoteiki District Court is under-resourced and ineffectual in dealing with these social problems, and its opening hours have been reduced. To improve social well-being in the Apoteiki District requires identifying key priority issues in the community, analysis of what services are available to address these needs, and the development of an action plan to tackle priority issues. This requires consultation, identifying partnership opportunities, designing programs to target justice and social needs, securing funding, and identifying appropriate service providers with efficient systems to implement, monitor and supervise programs, get feedback from stakeholders, analyse results and refine programs to maximise service delivery goals. In the Uawaras, government services are inadequate and spasmodically provided, with dwindling healthcare, social services, public transport and postal services. In some Uawara communities, the absence of public services and poverty has led to a sense of hopelessness, giving children little chance to succeed in life. The Waitangi Tribunal found the situation there had reached almost third world proportions, unacceptable in a fair society. There is high unemployment, drugs, perpetual violence and gang tensions. Subsection B. Lack of governance in the central North Island of New Zealand. Lack of governance in New Zealand in remote communities gained public attention at the trial of the Uawara 4. The alleged offending involved an organised criminal group with firearms operating military-style training camps in the Uawara mountain range near the town of Rotoki. The police asked the Solicitor General to consider laying charges under the Terrorism Suppression Act. There was concern people were planning an armed uprising to form an independent state on tribal land, if peaceful means did not succeed in settling Tuhoe tribal grievances with the Crown. More than 20 local people were charged with offences. The Supreme Court ruled much of the evidence obtained from search and surveillance operations inadmissible due to breaches by the police of the New Zealand Bill of Rights Act, and the majority of the accused were discharged. The process of getting to trial took 5 years. The trial for the remaining 4 accused, who were not discharged, was held in the Auckland High Court in a high-density metropolitan area, nothing like the small remote community they came from. The 4 accused were acquitted on charges of being in an organised criminal group, but were convicted on firearms charges. Justice Rodney Hanson said, when sentencing the 2 male Maori offenders to terms of imprisonment, that they were establishing a private militia which was undermining our democratic institutions and an enema to our way of life. The other two offenders, a female and a Caucasian male, her partner, received sentences of home detention for unlawful possession of firearms. the convictions are being appealed. One of the grounds is that the trial process failed to take into account the cultural and community context in which the allegations occurred. The defence argued that this was not terrorism. They were training to do security work. An ex-Navy drill instructor who put some of the participants through their paces in the bush said their skill level was abysmal. Tuhoe historian Tamati Kruger asserted the Tuhoe community would not have tolerated violent activism as alleged by the Crown. Academic Ruari Tuoni described the lead offender, Tamati Iti, as a master of theatre and not a terrorist. The academic argued that people involved were harmless, stating Rotoki will not invade Auckland. Who will pay for the gas? It is considered that due to the isolation of the area, no one was ever in danger. A local commentator posted on the internet the following quote: "The prevailing attitude with regard to the criminality of those involved, i.e. the possession of firearms, etc. So what? Everyone here has guns. Nobody registers for a firearms licence. There is no gas station here, so people keep petrol in containers. In short, no one did anything wrong, and we are innocent victims of the police." Rather than engaging with local community, the police used surveillance devices concealed on private Maori-owned land. There were complaints that the police were culturally ignorant, heavy-handed, and behaved like stormtroopers. The Rotoki community complained that they felt terrorised by the police operation. The actions of the police increased community distrust towards them due to the manner of the engagement. Peter Williams QC complained police breached the civil rights of the residents of the town. Local women said that they were ordered out of bed in the early hours of the morning by armed police who wore black commando gear. Children were subject to intimate body searches, and damage was done to homes which the police did not remedy. The police refused to apologise. The roadblocks took on the same formations as the historical confiscation line, giving rise to the grievances between Tuhoe and the Crown in the 1860s, relating to land confiscations. Dr. Peter Sharples, co-leader of the Maori Party, lamented that the terror raid on Rotoki set race relations back 100 years. Next subsection, the urban remote divide. The Uarua 4 case showed a deep fissure between urban and remote New Zealand. Professor Paul Moon describes that there are two coexisting worlds in New Zealand. One is predominantly urban, materialistic, outwardly secular, increasingly culturally diverse. The other New Zealand is tucked away in remote recesses like the Uawaras. It's indigenous, impoverished, and nursed on a diet of injustices that their ancestors endured, some as recent as just a generation or two ago. This case raises public awareness of the issues Tuhoe have against the Crown. Next subsection, the heart of the Tuhoe grievances against the Crown. Tuhoe remained in full control of their customary lands in the Uawaras until 1865. Prior to this time, the Crown had no official presence here. What lies at the bottom of their grievances arose from the murder of a missionary in 1865 in Opotiki. The murder was not committed by a member of the Tuhoe nation, but the person who instigated it fled to their land. The Crown unjustly punished Tuhoe. The Crown engaged in massive land confiscations of their most productive land, and they lost access to the sea. The Crown engaged in scorched earth tactics, extermination of non-combatants, and the execution of unarmed prisoners. In 1870, Tuhoe were forced out of Te Urua and detained, suffering hardship. The wars that followed caused Tuhoe to experience loss of life and widespread starvation. Peace was not restored until 1871, when the Crown withdrew its forces, agreeing to leave Tuhoe to manage their own affairs. From the 1870s to the 1890s, the Crown pressured Tuhoe to sell large tracts of their land by threatening to confiscate their interests if they did not sell. There is 150 years of grievances related to the wrongs committed by the Crown against Tuhoe. In 1896, the Crown put forward the Urua District Native Reserve Bill to allow the Uruas to be regionally autonomous as a self-governing people. The bill passed into law, but then Tuhoe were hit with frost and famine, and their population was decimated, and the self-governing idea went floating off into space. Next subchapter, the Crown Settlement. On 11 September 2012, the Crown and Tuhoe agreed to a settlement to be put to Tuhoe members for ratification and then developed into a deed of settlement and legislation. It involves a $170 million deal with shared governance of Te Ura National Park. The settlement creates a new legal identity specifying that neither the Crown nor Tuhoe own the land. The new board will be set up to decide what can occur in Te Ura. The Crown and Tuhoe will have to work together as they will have no power to veto each other's decisions in the management of Te Ura. Tuhoe are to have increasing management, administration and governance roles over time. The Department of Conservation will also maintain its role. The Crown will continue to fund the management of Te Ura, with Tuhoe contributing. This opens up new opportunities for economic development and new settlements right up into the middle of Te Ura. The settlement includes mana motihiki, redress, acknowledgement by the Crown of treaty breaches and an apology. It also includes relationship agreements with the government agencies and a plan for Tuhoe to develop their own social services over the long term, to lift Tuhoe housing, education and health standards. It allows for the provision of utilities such as broadband and better roads for those already living there. This settlement gives Tuhoe significant decision-making power over its future, consistent with the tribe's desire for autonomy. The settlement has been described as an elegant solution providing for reconciliation. The ability to adapt and design social services will suit their local needs, which will work well in Ratoki. It allows Maori to be able to solve their own problems in their own communities. Commentators believe that it is not likely to be the full and final settlement, and will never be, until Tuhoe get the nation-state they want so badly. Thank you for your time. I will be moving on now to present another video on my draft Chapter 5, which is Time for New Governments in Rural Disadvantaged Communities.